perfect time. Thank you. Good morning. So I decided to focus my talk on the story of Brooke Astor. Are any of you familiar with the Astor case? One hand. You know, I'm always sort of surprised that so few people know about it, but that's good in this case. The Astor case is to elder abuse what the O.J. Simpson case was to domestic violence. I mean, this is the most famous elder abuse case out there right now, the most publicized elder abuse case out there. So let's start. I have some video clips I'm going to show throughout the program. Let's start with a clip, and then I'll give you some more background about the case.
Before we begin,
The drama over guardianship is ruled inadmissible. This trial will be all about money.
What will the people prove? This case is about greed.
Prosecutor Elizabeth Lowy heads up the DA's elder abuse program.
They stole from her when she was at her most vulnerable.
Although she's not on trial, Charlene is depicted as the villain in the case.
Anthony Marshall's preoccupation with getting money for Charlene was actually a motivation for the scheme to defraud.
I really believe as though Charlene is driving this. Charlene wanted as much as she could possibly get. Even a few million was not enough. That she wanted everything.
The defense argues that Brooke Astor changed her will after softening toward her daughter-in-law.
The evidence is incontrovertible that Mrs. Astor understood what she was doing.
Prosecutors contend that Tony Marshall not only illegally changed his mother's will, but that he stole from her while she was alive, paying himself $1 million raise, using her money for expenses on his home and yacht, and taking valuable artwork of hers right off the wall. At the same time, he allegedly tried to keep his mother from spending money, telling her she was broke. Friends like John Hart testify with their own stories.
Tony told her that she was running out of money. It would be a theme of hers.
She said, I bought a lot of shoes, and Tony says I can't afford them.
So you've seen several of the players so far. Brooke Astor, you saw some photos of her. At the time of these events, she was 100, well, she had died at this point, but at the events in question, she was 101, 102, had been diagnosed with Alzheimer's about 6 years earlier. Her son, Tony, who was the son of her first husband, was 80-some years old at that point, and he was her agent under her power of attorney as well. His wife, Charlene, was his third wife. She had previously been married to Brooke Astor's pastor in Maine, left her husband in order to marry Tony. Brooke Astor did not like that, to say the least. Philip Marshall, you saw, bald man. He was Tony's son. He's actually one of two. He has a twin brother. He was sort of behind the guardianship petition that resulted from this case and has become an advocate for elder abuse victims as a result of what happened here. His twin opted not to be involved in any way in what was going on. There are three lawyers involved in this case. Henry Christensen, who had been Brooke's lawyer for a very long time, worked for Sullivan and Cromwell, and they had represented her for a long time, and Henry had sort of inherited her as a client from another partner in the firm. Francis Morrissey, who you saw a bit in the clips there, nice-looking man, was a lawyer, had been in trouble with the New York bar several times previously for similar cases involving older women who were changing their wills, and had gotten basically slaps on the hand, it looked like, according to the New York Times anyways. And he was, in New York social parlance, a walker. He was an older gentleman who would escort women, older women, to social events, parties, and so forth. So if they had no husband or no husband who was available to go with them, they had walkers in New York, they're called. So he had that role and a friendship of sorts with Brooke. Warren Whitaker, the third lawyer involved, I'll talk some more about when I get to the part where he becomes relevant, also a big firm lawyer. Some other people who helped, and I just like to point this out, though I won't get to talk much about them and you won't see them in this case. It's very rare when I get to talk about a case in which the butler was involved. In this case, the butler played a good role, though, not like, Miss Marple murder mysteries. He actually helped bring what was going on with her to the attention of David Rockefeller. I forgot to mention before, you saw a woman with grayish hair before. That's Meryl Gordon. She covered the case for Vanity Fair and then wrote a book called Mrs. Astor Regrets, that if you're interested in this case or the issue of elder abuse, I just urge you to read it. It's a really fascinating book. And she talks about the fact that Chris Eli was very concerned about what was going on, but felt that he could not violate Mrs. Astor's privacy. So he arranged to take her to a lunch with David Rockefeller, who was very good friends with Brooke, and Brooke did not want to go. She had become very scared and timid as a result of what was going on with her, and afraid of the men in suits who were dragging her down the hallway, because that was what the lawyers were doing to her and her son, were dragging her down the hallway in a different room and getting her to sign documents. So he got her to go to this luncheon, and then she was reluctant to get out of the car. So he said loudly enough for David Rockefeller to hear, "It's okay, there are no men in suits here." And David Rockefeller, of course, then, what in the world is going on? Annette De La Renta, Oscar De La Renta's wife, fashion designer, if you don't know that stuff, had been friends with her forever. Her mother had been good friends with Brooke. So David and Annette, were instrumental behind the guardianship petition that ultimately was brought. Told you before, Mrs. Astor, 101 at this time. Several events are relevant here. There's 3 codicils I'll talk about. The guardianship petition, I'm not going to talk about that very much, other than that was what brought this case to the attention of the district attorney's office. The guardianship petition was supposed to have been kept secret. It was leaked to the press, and lots of media coverage ensued, got the DA's office interested in what was going on. Let's go back a bit to, but just before I do that, what Steve told you about a couple cases that he's had, pretty typical cases, I think. And clearly, in many ways, the Astor case is not typical. I mean, we normally aren't talking about millions and millions of dollars. We're certainly not talking about butlers. We're not talking about people like Rockefellers. Henry Kissinger and Barbara Walters both testified in this case. You don't have that kind of thing going on. You don't have the press coverage that you have in typical cases. But when you strip all of that out, this really is a very typical case of a vulnerable, frail, incapacitated, or certainly at least diminished capacity older person being exploited by an adult child. All too typical, unfortunately. And people then interested and concerned about her struggling to figure out what to do to help her. The role that the lawyers played in this case, I think, may unfortunately be all too typical as well, and that will be the ethics stuff that I'll get into a little bit more. Let's take a look, though. Here's Brooke. You'll just see her for a second like this, but earlier days, better days.
I don't think she's ever had any tension in some way of handing over the foundation.
Not even to your father?
No.
As for her personal fortune, valued at more than $100 million, Brooke Astor told Barbara Walters it would mostly go to charity, too.
As the money was made in New York City, I wanted to give it all back to New York City. I just have a little bit left to still give and leave in my will.
What about Tony? He would inherit her New York estate, her Maine estate, and her 14-room Park Avenue apartment, worth in total more than $40 million, plus about $2 million a year in interest from a trust.
But, and this is a big but, Mrs. Astor really disliked Charlene, so that if Tony, who has heart problems, had died before his mother, all of that money would have gone to charity. All Charlene would have received was a diamond necklace and earrings and 2 used fur coats.
It appeared the reigning queen of philanthropy wanted to snub her daughter-in-law, Charlene. Meantime, Brooke Astor is fading.
You see, my mind is getting...
Friends know it, family knows it, Even Brooke herself knows it, says friend and film producer John Hart.
She greeted me at the front door and she goes, "John, I'm gaga."
So prior to the events in question, you heard her. She wanted the Astor money, the trust money that she was trustee for, to go back to charity, to stay in New York. She had been consistent in that position all throughout time, basically. She had tinkered with her wills a lot. She had made 32 wills and 7 codicils over a 50-year period, but that position was always consistent. Tony, her son, was not an Astor, as she constantly said. Remember, I said he was the son by her first husband. She did not want him to have control over the Astor trust money, and as you've heard, she did not like Charlene and did not want Charlene inheriting any of the money. So the plan was that if Tony died before Brooke did, the money would go to charity. It would not have gone to Charlene. Again, very consistent in that all throughout this period of time. So, Codicil 1, Henry Christensen is involved in this change. And really the biggest change here is twofold. Tony is pressuring Henry to change the will. Henry seemed to be pretty resistant, and he represented both Brooke and Tony, clearly a problem there. And so what he did was he labeled the codicil first and final codicil. Have any of you ever done that or heard of anybody doing anything like that? Yeah. Speculation is, of course, that he was trying to signal that he wouldn't do any more changes and that this really, was as far as he was going to be pushed. We'll see how it worked. He did give Tony control ultimately, or plan to, of half of the money in the trust, which again was not what she wanted. Tony was gaining a little other money as a result, but these were the major sorts of changes. Well, after... Were there other children? Pardon? Were there other children? No other children, okay? After this event, Henry was fired by Tony, okay? And clearly, Henry had been trying to avoid that. I think he was certainly afraid that that would happen and felt like he was being pushed and that he was going to lose one or both of them as clients. And that was ultimately what happened. He also then left his firm at that point. Whether he was pushed out or not for having lost them, who knows, but it would certainly seem like that was what was going on. So in his attempts to protect his client base, I would argue he didn't do a terribly good job of preventing his lawyer. He claimed that he mediated with Brooke to come up with this result and felt that he had dealt with this conflict of interest between his two clients. Well, how do you mediate with somebody with diminished capacity? Did she have the ability to give informed consent to waive the conflict between them? I would certainly argue that that was not the case in the condition that she was in at that time, and that the conflict was so enormous that it really wasn't one that should be waived anyways. Let's go back now, see some more video.
Then, a few years ago, Brooke Astor, who often tinkered with her will, began giving things away. During a visit from Philip, she offered him this cottage on her multi-million-dollar Maine estate.
And when your dad learned that she had offered you the cottage, how did that go over?
At the time, he sort of said, well, it will cost you money to maintain and taxes and all this, and you can always stay there. It's like, fine.
But after Philip passed on the cottage, Brooke gave the entire property to Tony, who then signed it over to his wife.
Well, she would not have wanted Maine to go to Charlene.
And why do you feel so certain of that?
Well, because I think she probably didn't want much to go to Charlene.
It was the first in a series of events that would lead Philip and some of Brooke's longtime friends to question what Tony and Charlene were up to.
Tony began to fire a lot of her very close staff members. He will argue he was saving money. Others say he was isolating her.
But what concerned Philip most was his father's decision to close his grandmother's beloved country house in suburban New York, Holly Hill. Why did your father decide to close Holly Hill?
The rationale was there wasn't as good medical help. We found out later that there was plenty, in fact, incredible medical services out in Holly Hill and around there, and that's where she wanted to be.
Tony had fired the butler, Chris Eli, and Mrs. Astor thought he was dead because that was, in her mind, that was the only reason why he would have just vanished. You know, they never told her that he'd been fired. He just didn't come back to work the next day. And after the guardianship was put in place and he was able then to come back and see her, she just sobbed because that was what she had thought, that he was dead, and she thought the world of him. So, you know, the personal impact of this stuff is huge, as well as the monetary impact. So now we get into the events of Codicil 2, where, among other things, the main property was given and ultimately given to Charlene. Tony continued pressuring Christensen, as I said, and then with Morrissey's involvement, Morrissey's the Walker lawyer, Tony fired Christensen, and they hired Warren Whitaker. Warren Whitaker was a big deal in the ABA. He was the previous chair of the ABA's Real Property and Trust section. Whitaker never met with Brooke Astor. He drafted the second codicil, took it to her to sign. He said that he felt that she had capacity to sign the second codicil because she was all dressed up and made up. Well, yeah, she had staff who dressed her up and made her up. And that they had a very lovely conversation, coherent conversation, about her life in China as a child before the Boer War. She was not alive at that time, so clearly it couldn't have been a very coherent conversation. He did absolutely nothing to assess her capacity and determine, he didn't even determine who really was his client, and he certainly, again, did nothing to assess her capacity, deal with the conflict of interest that he had in representing her and her son, who clearly had adverse interests to each other. Christensen tried to contact Brooke at this time, but it was very feeble. He did nothing to protect her. He could have had Rule 1.14 Model Rules of Professional Conduct been in place in New York at that time, he could have petitioned for guardianship to try and protect his client, but he took no action like that. The second codicil had a lot more impact in ways that Brooke never had wanted. It provided that if Tony died before Brooke, that the money would go to his estate, which meant that Charlene would have inherited it. It named Tony as the sole executor, and then he promptly, a few days later, turned around and named Charlene and Morrissey as co-executors, which Brooke did not want. And it eliminated the unitrust, the charitable unitrust, and gave $30 million more to Tony, which again, Brooke did not want. Then what happened is Whitaker, of his own accord, prepared a third codicil. He said it was for tax reasons. And he didn't even go to the execution at that time. He sent Morrissey to do it. And that is the codicil that was allegedly forged. And you can see up there the circumstances of how the codicil was put together, where it was really pretty easy with the signatures being both on the third page and the fourth page rather than the same page, that the witnesses could have signed at a later time, as was suspected. And Brooke Astor's signatures looked nothing like they had previously. So I've talked about the impact that the third codicil had. Some other issues, and you heard allusions to this in the previous section of video that I showed. The paintings, he stole one of those paintings right off the wall of Brooke's house, sold it at Sotheby's or wherever, for a couple $1 million. He got a lot of money as a commission for having done that. He gave himself a $1 million salary increase retroactively for his role as her agent under the power of attorney. Tony was a Tony Award-winning theater producer. He paid the salary of one of his staff with Brooke's money, I think the boat that we saw, he used some of her money for that. So he clearly was misusing his authority as her agent under her power of attorney, in addition to what was going on with changing the wills, changing the codicils. So both Marshall and Morrissey were prosecuted by the New York DA's office. Both of them were convicted on multiple charges related to all of these events. Both were sentenced to prison. Both went to prison. Tony was released about a little less than a year later, though the prison system had said that they could take care of him given his age and health condition. They then changed their mind, and they actually pushed to get him out of prison, and that was allowed. As far as I know, Morrissey is still in prison. Morrissey was disbarred automatically by the bar because of the convictions for the felonies. So the previous bar discipline had not stopped this pattern of practice, but this took care of it. Let me show you sort of an end clip here, and then we're
Still,
going to have
even
time
if
for
Brooke Astor
questions.
was a prisoner of Park Avenue, it was Park Avenue, with servants and nurses and doctors available around the clock.
There was no one who was really in charge.
Was the house dirty in New York?
New York was dirty.
Philip says staff began confiding in him.
He was asking questions, and the nurses unloaded, and they expressed all sorts of concerns about cutbacks in the household. And the implication was that Tony was not really running the show.
These photos of the apartment were obtained exclusively by 2020.
Repairs weren't being made in the apartment. The chauffeur who used to walk the dogs had been fired, so the dogs were no longer being walked with somewhat predictable results. I don't think she was necessarily in danger in any way, but clearly appearances weren't being kept up the way they had been during her, her better days.
I think they had other priorities.
Such as?
Themselves.
So here we have a case of a woman with huge wealth who, while she wasn't being neglected in the sense of that we look at of elder abuse, where people are left to rot to death from bed sores and aren't fed, aren't cared for in any ways. That wasn't what was going on, but she clearly was not being cared for and treated in the way that she had been accustomed to, and that she could still well afford. She could afford shoes, she could afford dresses, and Tony was just trying to keep the money for himself and for Charlene, instead of fulfilling his obligation as Brooke's agent under the power of attorney and his familial obligation as her child to care for her. I always say that families put the fun in dysfunctional, and clearly there was some dysfunction in this family, as I think there are in most. And that, again, is what makes this case so typical, and what you may see, not with millions of dollars in your practice, but very typical in what goes on with kids coming in and asking for you to prepare a power of attorney for a parent. Do you talk to the parent or not? I have certainly met elder law practitioners who have prepared a power of attorney at the child's behest for parent, never talked to parent, again, did not assess who their client was, whether there was any sort of conflict of interest, and then child promptly used power of attorney to exploit parent, and one day the cop showed up at the lawyer's door investigating the lawyer's involvement in this exploitation of the father. You've got to look carefully at these cases. You've got to think through, does this client have capacity or not? And that's not an easy thing to tell. There are no magic tests right now to determine whether somebody has capacity or not to make decisions. And science is advancing, and I think in time we're going to get to having some tests that really will help lawyers as well as neuropsychologists and physicians determine whether somebody has capacity or not, but we're not there yet. We, the ABA Commission on Law and Aging, in conjunction with the American Psychological Association, produced a series of guides on capacity a couple years back, one for lawyers, one for judges, one for psychologists. You can get that off of our website. I referenced the document in my outline, which is in your materials, so you can find the title of it and find it on our website. And I would behoove you to look at that because it really does a great job of explaining the legal view of capacity, why it's relevant, what lawyers look at in making capacity decisions, because you do that every day, or you should be doing that every day with your clients, particularly those who are older or who have some type of disability that might impact their cognitive ability to make decisions. You make that decision in determining whether you can form a lawyer-client relationship with that person. You make that decision in every day in saying, does this person have the capacity to sign the will or sign the power of attorney or sign this deed or anything else that they're trying to do? You then may have to make some decisions about whether the person had capacity at the time of past events, such as in this case, as to whether there was capacity back then and therefore or not, and do you have grounds to bring a lawsuit and try and get the money back, get the house back or not. And as well, protective services workers and to some extent law enforcement officers and prosecutors also deal with these capacity issues every day. These are really the crux of what's going on in elder abuse cases. Just because you're old or just because you have some sort of disability or impairment doesn't necessarily mean that you lose capacity. In the early stages of Alzheimer's disease, you still may have the capacity to make decisions. Just because you're in a nursing home doesn't mean you lack capacity to make decisions. And all of these things take a lot more thought and a lot more consideration than historically we've been giving to them, in part because this is while it's not a new problem, it's sort of new in our understanding that this goes on, that it goes on to the extent that it does, as Steve talked about earlier. Once you learn about this stuff, you see it all the time. That's sort of unfortunate. It skews your worldview of families and what people do to each other. But it really does happen a lot, and it just doesn't get much attention. And we look at it through different lenses in the law, and we need to shift those lenses. So let me just wrap up before questions. Tony died late last year. Philip learned of his father's death from Merrill Gordon, the book author who I told you about, who had learned of it from the New York Times, who learned of it from Charlene, who wrote her own obituary for Tony, her husband, which made no mention whatsoever of his 2 sons, of his 3 grandchildren, or anybody else. It was just her view of Tony, and the New York Times published it, but also published its own obituary, which didn't whitewash the case as Charlene had done. When I practiced long ago, I was a legal services lawyer working only with older clients, and my very first case was an elder abuse case. As it turned out, I didn't recognize that at the time. I didn't know what those words were. It was literally my first week of work. But I learned over the years, and when I would prepare powers of attorney, would always really talk with my clients about what if you're giving this authority to your son. Think about your son and the possibility that he might misuse this authority. And they would always, no, that would never happen. My child would never do that to me. And I'd say, okay, what if your son married a bad woman? And I'd see in their eyes, oh, yeah, that could happen, but then the shades would come back down. No, he would keep her. He would keep her from doing anything, that would harm me. But that's exactly what this case was. Tony married a bad woman who pushed him to benefit herself financially, which led him to exploit his mother. And that's what goes on in these cases. As Steve pointed out, it's not always clear who's the good guy, who's the bad guy. in these cases. Who's right, who's wrong, particularly if you have squabbling children. So you just got to be really careful. I don't want to say never serve older clients. Of course, we want you to serve older clients, and we want more civil lawyers taking elder abuse cases because that's a critical part of providing protection to victims and of helping them recoup their losses. But we also don't want you needing the services of Judy Smith and facing bar discipline. And so think through these cases, and we at the Commission certainly try to help with resources that we've developed. So we have 15 minutes for questions and answers, discussion, whatever, just like I hoped we'd have. So the question was, are lawyers required by law to do anything if they suspect elder abuse? It depends on what state you're in. So we've talked about adult protective services. If you're not familiar with what that is, adult protective services, like child protective services, receives reports about suspected elder abuse or adult abuse. I'll come back to that. And then it makes an investigation, and if it substantiates the abuse, it can provide or arrange for an array of protective services to the victim. It might refer them to legal help. It might refer the case to prosecution. It might get home care and meals into the home. I won't go into a lot of background about APS, but investigation and then provision of services. All states, except, ironically, New York, have in their adult protective services law some sort of mandatory reporting provision requiring either everybody or listed professionals to report suspected elder abuse or adult abuse to APS. In some states, as I just said, everyone is a mandated reporter. That would include lawyers. In other states, lawyers are specifically listed as mandatory reporters. It's not that many states, but it's more than a handful. You can look. We have charts on our website. They're out of date, but still would get you pretty close, and I'm working to update them, that indicate who's a mandatory reporter and who's not. You've got to go back and look at your state law as to whether you as a lawyer are a mandatory reporter. Now, as to then who you would need to report about and about what you need to report, it gets really more complicated. So you can't just look at the mandatory reporting provision in the law. You have to understand how your state law defines elder abuse or adult abuse and who it protects. Okay, that can get really messy. We also have charts about that. You may be required to report for anybody 18 and up. If they have a vulnerability, an impairment, your law will spell all that out. It could just be people who are 60 and older. In California, it's 65 and older. Or it could be 60 or 65, plus they also have to have an impairment or a vulnerability. And if you're confused, then you totally understood what I just said, because it's really confusing. Okay? But, are you a mandatory reporter? If so, does this fit into the circumstances that APS will investigate? And then you're going to have to look at your state's ethical provisions and whether, in complying with your state law, are you violating your state's ethical provisions. And I don't have answers for that. You could be, depending on the circumstances of the case. And then I would just say, call your state's ethics hotline and get some help from the bar disciplinary folks up front about dealing with this conflict or potential conflict that you have. Now, what do you do if it's one of the gray cases? And most of them are the gray cases. And you just have some doubts. Your gut maybe is telling you something. What do you do? I recommend that you, with all your older clients, and maybe you want to expand it beyond your older clients too, that you do some screening with everybody about financial concerns and the possibility of financial exploitation, okay? If you do that with everybody, there are a couple benefits. First, then you can say to that client, I do this with everybody. There's nothing particular about you that's causing me to think that there are these issues going on. I do this with everybody. Because most clients are not going to come in and disclose that they're being exploited or physically or sexually abused. And those things happen, and they usually happen together. It's very rare to have just one type of elder abuse going on. And it also makes you feel more comfortable. You do this with everybody, it gets easy. If they won't disclose anything to you at this point, clients have said to other lawyers I know, well, I wasn't ready at this point to share this with you, but I knew that I could come back to you down the road and tell you about this because you indicated to me some knowledge and some concern, and I just needed to get to the point of feeling safe, basically, in disclosing this to you. If you're concerned about capacity, and I argue in all of these cases you should be concerned about capacity, get our capacity guide and really look at the steps that you can take to first try to eliminate things that might be causing some confusion that aren't really capacity. It could be that they can't hear you, and they're not going to admit that they can't hear you. It could be that they can't read and won't admit that they can't read. And that was really a problem for me with my legal services clients in the 80s. It's still a problem now, though. And some people just can't read. They might be dyslexic, or they may have vision problems that they just can't, they are capable of reading, they just can't do it at the moment. So things like that you can try and fix so that there's less confusion and possible incapacity going on. You can you can refer your client with their permission to someone who is capable of doing a more formal capacity assessment, which could be a geriatrician, if you have any in your community, a doctor, a neuropsychologist. Don't assume that every doctor is capable of doing a proper capacity assessment, or a psychologist could do them too. But yeah, they're not all trained and trained well in doing this. Most of them aren't, so you want to try and find someone who do this regularly and really know what they're doing. Does that help? Yeah. Okay. And I certainly believe in trusting your gut. So in a nutshell, in case you couldn't hear in the back, what do you do in the really nasty, because they are nasty, cases of undue influence, which we are increasingly recognizing is a real and growing problem in elder abuse cases. It's not just about changing will anymore. And if you go back and look, as I have been doing, because I do a lot of training on undue influence, and you go back and look at cases from the 1700s, the 1800s, that are the precedent undue influence cases in the state, they're elder abuse cases. Just no one used those words back then. The undue influence cases are really difficult, I think, first to recognize, and kudos to you for recognizing that it might be happening. Because with undue influence, I've now started describing it as, comparing it to the adage of, if you put a frog in boiling water, it'll jump out, but if you put a frog in cold water and turn the burner up under it, you're going to cook it to death because it doesn't recognize what's happening to it. That's what undue influence is, and it's really pretty easy, relatively, in retrospect, to look back at an undue influence situation, and when you can see all the pieces that contributed to boiling the frog and put it together. But when it's going on like that, it might be really difficult to tell what's happening. And like Steve's case, like your case, it is easy to get into ethical problems with that. Clearly there was enough in your case where you picked up on what was going on.
No, I was representing
so you were after. You okay, okay.
But I've never been in that situation. I thought about his position and what I would do.
Okay.
And my question is, how do you deal with that ethical quandary? Do you report this to the group, and can you do so without violating?
All right. Well, thank you. I misunderstood. I thought you had done both aspects of things. You always want to separate your client from whoever has brought them in and talk to them for a period of time to see, is this their volition? Is this the child's volition? But in an undue influence case, they're going to believe that this is of their own volition. What's going on in undue influence is that the influencer is just creating a false world, in effect brainwashing them into thinking that what the influencer says is happening is what's happening, and that's not really what's happening. So separating them probably won't work. You're going to have to do some investigation up front, like what Steve did. It wasn't an undue influence case, but he had the connections to do some investigation up front to see what was really going on. And if the client, the older person, and the person who's brought them in are saying, oh, she wants to change the will and leave everything to me because the other kids don't care about her and they never show up. Can you, without violating confidentiality, do some investigation as to whether that's really the case? And I don't have an answer for you. But what the other kids might say in that situation is that they've been trying to visit mom, but influencer is keeping them away from her. If they show up at the house, they're being told, mom's sick, mom's sleeping, she can't talk to you now. If they call, mom is never allowed to talk to them on the phone. That's the kind of stuff that's going on. If the police or anybody else show up, they're being sent away, and either mom's telling them everything's okay because she thinks that it is, or influencer is pushing everybody away. I helped some people with a case in Florida where a woman, an heiress, had married a man who was the age of one of her children, had been the family's financial advisor for many years. They would go out, so undue influence, one of the key criteria you look at is whether the victim is isolated. Well, they would go to the country club. Oh, they're not isolated. He would go in the women's room and make sure everybody was cleared out of it before he would allow his wife to go in the women's room so that she had no opportunity to talk to anybody else there. You've got to dig into these cases. Whether you can do it without violating confidentiality, I think you need to try and be creative and find some ways to do it, but it's a real problem. Well, I talked about our capacity manuals that are up on our website and told you how you can find the name and the link to them. This experience issue that Steve arranged for you to have copies of today has 2 really good articles in it, I thought, about ethical issues and diminished capacity. Michael Kirtland's article, he's an elder law attorney in Colorado, I think really raises some interesting issues about the impact of Rule 1.14 and, okay, you attempt to protect your client by petitioning for guardianship, but then what happens, and that Rule 1.14 really doesn't address what happens after that. And I think the reality is that the model rules don't work terribly well for these elder abuse cases and financial exploitation cases, and particularly the undue influence cases, and that we need to start thinking about changing them, and that's something that we're extremely interested in working toward at the Commission. These rules were written by lawyers who weren't involved in elder abuse cases, who don't get these issues, and I think some changes are necessary to protect you, really, and to protect your clients and the Brooke Astors of the world. So thank you very much.